Hello students, welcome back to the daily news analysis. Today we'll be discussing the important news article of 29th of April 2022 and I am your educator Prithviraj Singh. Let us begin with the session. On the very first page of the Hindu, there was a news article about Afpa, very much in news, something which is very much debatable, contentious. Yes, I am talking about the Armed Forces Special Powers Act. Now this act gives special powers to the armed personals, to the armed forces, right? Special powers in the sense that those areas which are being declared as disturbed areas, especially in the northeast states, the armed forces, get special powers, and those disturbed areas, if anyone is seen breaking the local laws, the armed personnel would actually can shoot a fire, right? They can order the fire, and even they can search the premises without any arrest warrant, right? So in this sense, this act which came into being, which was enacted in the year 1958, its genesis lies in the year 1942. All the Afpa as an act came in the year 1958. But you all would be knowing the Quit India movement of 1942. Now this was a pan-India movement, and the slogan that was being raised by Mahatma Gandhi was "Do or die," right? This also turned to be violent in some areas. And in order to maintain the law and order, the British officials passed the Afpa, right? In order to maintain the law and order in the country and to control the situation which was actually going out of their hand, they passed Afpa to control the Quit India movement, right? Armed Forces Special Powers Act. Now in this, the armed forces get special powers. They get special powers with regard to the disturbed area, which is the area which has been declared as a disturbed area. They can order the battalion to fire over the people assembled if they are found to be flaunting the law which is in force. They can also arrest any person without any arrest warrant. They can also search any premises or any property without any search warrant, right? So these powers, extraordinary powers, were given to the armed forces, right? Now, well, as you can see, that it was a draconian law, a British-made law. After independence, there was huge increase in the insurgency, especially in the northeast region, plus Punjab. And after the formation of the formation of the Constitution of Jammu and Kashmir and conferring it special status, there was also insurgency and militant activities in the state of Jammu and Kashmir. However, now it is a union territory, right? So the same act of the British colonial law, the same colonial law of Afpa, which was actually first used to curb the activities in 1942, was then later passed by the Parliament of the independent India in the year 1958, and it was made applicable in the northeast states, Punjab and Jammu and Kashmir. Guys, the intention behind the law was pure, to actually curb the militant activities, to curb the insurgency, to curb the disturbances, right? But then lately it has been seen that it has been used as an instrument for human rights abuses, human rights violations. And recently, the last year, 2021 December, army killed around 12 people by claiming Afpa, right? So Afpa has been actually misused for many years. it has been breached, it has been misused for many years, and it has seen various human rights violations where even armed personnel are being involved, in such human right abuses. And there is a completely different set of process, to actually bring the armed personnel into the court of law, right? So in this sense, we are clear with the Armed Forces Special Powers Act and its background, right? So they may ask you that in which year it was enacted. Answer is 1958. In which all states it was applicable? Northeast, Punjab and Jammu and Kashmir. Now, we all know that the present government would be celebrating the 75 years of independence on 15th of August 2022 this year. They would be celebrating Azadi Ka Amrit Mahotsav. And Prime Minister Modi has declared that by 15th of August this year, all the disputes, the boundary disputes in the northeast states would be resolved. And they have, because of the Bodo Accord, now the situation in the northeast states, especially Manipur, Nagaland and Assam, also seem, there are peaceful conditions. So therefore, Prime Minister Modi, who went to Dibrugarh, Assam on Thursday, that is yesterday, has told the people that the valley has returned to peace, and it has been around a decade that no violence has happened. And that is the reason why he has assured that Afpa would be withdrawn, if not completely, but at least partially, from the three northeast states of Assam, Manipur and Nagaland. So he has assured that Afpa would be partially removed from Assam, Manipur and Nagaland, right? Now, the problem of insurgency in Assam's Bodo areas and Karbi Anglong in Tripura and the Bru tribes, right? The Bru-Riang problem in Tripura, Mizoram also seems to be resolved. So there are peaceful conditions in the valley, and therefore, Prime Minister is assuring that the Afpa would be partially removed from these three states, Assam, Nagaland and Manipur. I hope it is clear. At the same time, there are various development projects which the central government has started in the northeast states. They would be building various water conservation projects across Assam. 3 regional colleges will be built in Assam. Similarly, they would also be building a super specialty cancer hospital, because of the reason that Assam in the northeast states has many cancer cases, right? So therefore, it would be a big boost in the medical infrastructure. So therefore, government is actually pushing the the infrastructure development in the northeast region. So we are done clear with the Afpa. Now let us understand the nitty-gritties of the act. Afpa, as I said, was there in the northeast regions, and as I said that it gives the person in the army, in the armed forces, of the rank of commissioned officer, the warrant officer and non-commissioned officer, or any person of the equivalent rank in the army, to fire upon or use against any person acting in contravention of any law for the time being in force. That means the armed person can, order the fire on the people assembled, right? If they are being found in contravening or violating or flaunting any law which is at force at the disturbed area. They can also arrest the suspicious people without any arrest warrant. They can destroy any structure suspected to house an arms dump. At the same time, they also can conduct searches without arrest warrants, right? So in this sense, it is definitely a draconian law, and the time has come that it has to be reformed. And in many states, it has already been withdrawn, right? We'll see how many states have actually seen the withdrawal of Afpa. Guys, you all would be knowing about the activist Iram Sharmila. Now, he was a Manipuri activist, and she was there on the hunger strike for 16 years against Afpa, right? And therefore, it is very much something very important. Now in these states, as you see, it is still applicable. Arunachal Pradesh, Assam, Manipur, although in Meghalaya it has been repealed in the year 2018. In Tripura also it has been repealed in the year 2015. Mizoram and Nagaland, it is still there, right? Correct. Mizoram, they have Mizoram also. I'll correct it. Mizoram, it has been repealed in the year 1980s, right? So guys, there have been 3 states where the Afpa, northeast states where the Afpa has already been repealed. The first northeast state where Afpa was repealed was Mizoram in 1980s. Very important, very important, and the examiner might actually ask with a question on these lines, that which among the following northeast states has seen the withdrawal of Afpa, right? So please make the facts very clear. They may ask you on these lines. So the first northeast state where Afpa was withdrawn was Mizoram in the year 1980s, that decade. The second one was Tripura in the year 2015, and the third state which has seen the repealing of Afpa was Meghalaya in the year 2018, right? So the code is ~MTM, right? And it would start with Mizoram, Tripura and Meghalaya, right? That means in Manipur it is still operating, right? Mizoram, it has been gone in Mizoram, in Tripura and in Meghalaya, right? Whereas in Manipur it is still in operation, right? However, the government, as I said, is assuring that they would soon partially repeal Afpa in the state of Assam, Manipur and the nearby state of Arunachal Pradesh. So as you can see, even in Punjab it was being repealed, right? So it's no more in Punjab. Mizoram we have discussed, Tripura and finally Meghalaya, right? So coming to the first screen, as I just mentioned, that the government has assured that they would be partially withdrawing the Afpa from the state of Assam, Nagaland and Manipur. Now, as far as Arunachal Pradesh is concerned, there are many districts, in Arunachal Pradesh over which the Afpa has already been removed. And even to that extent in Manipur also, it has been partially removed in the 7 Imphal Assembly constituencies. So in this way, Afpa do cover all the northeast states, where it is applicable, except the things that we have mentioned, even though it does not apply until a particular region is designated as a disturbed area. So Afpa apply karne ke liye ye governor has to declare it as a disturbed area, right? So Afpa is now in all applicable fully only in 31 districts of the 4 northeast states. And we have already discussed that in Tripura, Mizoram and Meghalaya it has already been repealed, right? So now it has been very limited. It is limited just to the 4 northeast states in the 31 districts. That means it is not applicable to the full state, right? So I hope it is clear, right? So this is all the details about the act. A very important act, and there is high possibility of it being asked in the examination. Coming to the next news article, guys, government has assured that they would be rolling out the 5G services, right? The broadband services, which is being said to be the high-speed broadband services, right? Broadband network services to the LTE or long-term evolution, right? Long-term evolution mobile networks. Now this latest upgrade to the LTE mobile networks would be rolled in the month of August and September, right? So the government is working in rolling on the 5G airwaves, and they are high speed, they would provide high speed data network. And although it has 3 bands, low band spectrum, mid band spectrum and the high band spectrum. In the low band spectrum, the range, I mean the speed would be less, it would be around 100 Mbps, but then the range would be very high, right? So definitely 100 Mbps is also not a small speed, but then it has low band spectrum, right? And it may not be optimal for the specialized needs of the industry, right? Now for the domestic purposes it may work well, but then not for the special needs of the industry. Then it has a medium band or a mid band spectrum which has the speed higher than 100 Mbps, right? So it may be used for, you know, in industries and specialized factory units, for building captive networks, correct? So this is how the evolution has taken place from 1G in 1980s to 2G in 1990s, which was based on digital voice, to 3G post 2000, which is based on CDMA mobile data, and now 4G from 2010 onwards, which works on the LTE and LTE advanced technology and gigabyte LTE. Now we are prepared for 5G spectrum, right? 5G rollout, which would give a wireless edge, right? With the 5G new radio NR technology and everything, even I mean your automobiles, your domestic appliances, the factories, industries, drones, they all would be operated through the high speed data network, right? So 5G would be a game changer. It is a revolutionary move, right? Now, as I was discussing that it has 3 band networks, the low band, mid band and the high band. In the high band, the speed would be as high as 20 gigabytes per second, 20 Gbps, very big, very high speed, and it would be used for specialized services, right? So in this sense, there are 3 band spectrums, and this is a revolutionary step. Now, where does India stand in the 5G technology race? Guys, it is definitely we are on par with the global players, and all the 3 private telecom players like Reliance Jio, Infocom, Bharti Airtel and Y have been urging the Department of Telecommunication to lay out a clear roadmap of spectrum allocation and 5G frequency bands, right? And with that, and one big hurdle, however, is the lack of flow of cash. So there was lack of flow of cash and adequate capital which is necessary for setting up the 5G towers, with at least 2 of the 3 players, namely Bharti Airtel and Vodafone Idea, right? Now, when I compare it with other countries, definitely America has already, you know, is progressing on the 5G path. The companies like AT&T, T-Mobile, Verizon, etc., they have already installed the 5G setups, and they are pushing in that direction. China also has some of the telecos in China like Unicom, etc. They have already started the 5G trials as early as in 2018, right? And they have already rolled out the commercial services for 5G. Even a South Korean company, Samsung, it also has started researching on 5G technology, right? Back in the year 2011, right? So these countries have already, run the trials, and they have already have 5G in operation, right? So here we are clear, and the takeaways from this is definitely there are 3 bands: the low band, mid band, and the high band, and the top speed would definitely be 20 Gbps, and the government is rolling out and they're planning for the month of August, right? So that's all. Now moving to the next news article on the screen, it talks about the debate which has sparked various protests in the country, and Prime Minister Modi yesterday declared that although we have cut down the excise duties on the crude oil, on the petrol and the diesel, but the states are not passing the the lower prices to the customers, because of the reason that they are not lowering down the VAT, right? So we must understand that if a liter, I assume that if a liter of a petrol is costing you 100 rupees, 50 rupees are being, the tax, I mean, they are the duties or the taxes. 50 and remaining 50 is definitely the cost, and the 50% is the tax and the duties. Now these tax and duty, when I say, I mean the excise duty which is being levied by the central government, and the VAT. value added tax, right, where the petrol is being sold, right. So VAT is a state subject and excise is a central subject, right. So the central government is saying that we have already lowered the excise duty, but then also the prices of the petrol are still high. Prime Minister Modi has said that the non-BJP ruled states are not lowering the VAT, are not lowering the value added tax, and that is the reason the prices of the petrol and diesel are still high, right. Now, many people have protested against this statement, and even Rahul Gandhi has said that Modi government is following coercive federalism instead of cooperative federalism, right. So this is all about this. So as I said that the central and the state taxes form a major chunk of the price of petrol and diesel in India, right. While excise duty is constant for all over India, the state taxes, that means the sales tax and the VAT, they vary, depending upon the rates levied by the different state governments, right. So this is all there. So they are saying that it is not cooperative federalism but coercive federalism, right. So as I said that VAT or value added tax is a type of tax that is charged by the central government now, because now it is an indirect tax on the sale of services and goods to the consumers, right. However, it is being levied by the state government, and we all know that petrol is still out of the GST, right. So therefore it is still being charged by the state government under VAT. Coming to the next news article, as you can see on the screen, Supreme Court panel flays Assam on Kaziranga animal corridors invasion. Guys, Kaziranga National Park is famously known for the one-horned rhinoceros, right. Kaziranga National Park is also a tiger reserve, and it is being known for one-horned rhinos, which is definitely a endangered species, and it is also a tiger reserve. Now, it has been seen that during the monsoon season, the Assam Valley gets flooded, the Brahmaputra Valley gets flooded, and the rhinos have to move out from their territories, right. They move out, and in the search of safe habitat, they possibly have to climb the hills, and there they are being poached, right. So the area which surrounds the Kaziranga National Park, the Supreme Court has banned all the construction activities, all the illegal construction activities in and around the Kaziranga National Park has been banned by the Supreme Court, right. But sadly, there has been a lot of construction activities in the animal corridors. Corridors means the passages where the animal actually commute from one forest to the other. So the Supreme Court has actually given a notice to Assam government against such illegal construction activities near Kaziranga National Park. So very, very important, Kaziranga National Park in Assam, right, and it is known for one-horned rhinoceros, right. So very important, and it has been asked various times in the examination. It has also been declared as UNESCO World Heritage Site, right, because of its environment and the wide species that it resides there. About Kaziranga National Park and Tiger Reserve, as I said that it is a national park, and it has also been declared as an important bird area by BirdLife International. It is home to 4 important wildlife species: rhino, elephant, Royal Bengal tiger, and Asiatic water buffalo. Right, I hope it is clear. And so the national park also has more than 250 seasonal water bodies besides the Diflu river running through it, right. So it is Diflu river which runs through it, and it is again a tributary of Brahmaputra. Editorial page. On the editorial page, there was a very important article with regard to death penalty. Guys, death penalty in India is still being declared by the judges, right. Sadly, we have grown into the constitutional jurisprudence, and at this stage, I mean, it is something which has to be, looked upon, which has to be talked upon. Recently, in Irfan versus state of Madhya Pradesh case, where the local court has given the death penalty to Irfan, has been actually challenged in the higher courts. This is a time, students, where we must critically examine the routine and abrupt way in which the trial judges, I mean the lower court judges, often imposes the death penalty on convicts. Right? Guys, 180 कंट्रीज में डेथ पेनल्टी ऑलरेडी हट चुकी है, और उसमें से 160 कंट्रीज की अगर मैं बात करूं तो उसमें लॉ मतलब वहां के जो लॉ है, देयर लॉ हैज आल्सो बीन actually rejected the death penalty. It is no more functioning there, right? So we as an advanced country also, this article says that we as an advanced country must also look upon the reforms in the capital jurisdiction, and the approach should be not convict centric, but the approach should be convict centric and not offense centric, right? And when we actually look from this approach, we understand the rights, the apathy, the background of the convict, right? So that means we must follow, this article is saying that there must be a humanistic liberalism approach to be followed, right? Now, various cases, Supreme Court cases, have been explored in this article. It says that you must actually look at the offender rather than the offense, right? And offender is also a human being. He may be coming from a background which actually forces him to do or commit such crimes. Definitely, I understand that a crime is a crime, but then in constitutional jurisprudence, this is something which has to be looked upon. There is need for mitigation experts to assist the trial courts. This article is also recommending that in the courts, the psychologists, the social workers, the team of all the psychiatrists, they must be called upon to actually understand the psyche of the convict, to actually appreciate whether the death sentence should be given or not. In this way, a multidisciplinary wisdom relating to the crime must be followed. Now, the case is definitely Irfan versus state of Madhya Pradesh, and the previous cases are also being explored, like Lochan Srinivas versus state of Chhattisgarh 2021, and Bhagya Chandra versus state of Madhya Pradesh, the recent case in the year 2021. Now, an analysis of the possible reasons to avert the death penalty is reflected in a series of cases, right? So the article is exploring that are there any mechanisms or mitigating factors by which we can avert the death penalty, which is the highest form of or the most brutal form of punishment. So recently, Lochan Srinivas versus state of Chhattisgarh 2021 and Bhagya Chandra versus state of Madhya Pradesh 2021, in these cases, the court has come up with the reasons like including the socio-economic backwardness, mental health, heredity, the bad parenting, socialization, education, etc. in actually averting the death penalty. At the same time, we must understand that there is a section in CRPC called as section 354 clause 3. It says that while the court is imposing the capital punishment, the judges should specify the special reasons for doing so, right? So even if the judge is declaring a capital punishment, the special reasons for it must be actually declared, right? So in this sense, it is a positive provision. Very, very important case in the death capital punishment jurisprudence was Bachan Singh versus state of Punjab 1980. Guys, very important, Bachan Singh, and they may ask you on this, very important, Bachan Singh versus state of state of Punjab in the year 1980. Now this case became a landmark case in the death sentences or in the capital punishments. Also very important for the students preparing for the UPSC exams. In this case, guys, for the first time, the Constitution Bench suggested that a humane and reformist framework should be adopted, right? And the death sentence should be given only in the rarest of the rare cases, right? Only when the offense is too grave. I mean, when the case is rarest of the rare, only in those cases the death penalty or the death punishment can be given, and not for the ordinary offenses, right? So very important, they have given the doctrine of rarest of rare. Rarest of rare means only in rarest of rare cases the death punishment can be inflicted, right? That too when the alternate option is unquestionably foreclosed. That means there is no other option left, and the crime is rarest of rare. Only in these cases the death punishment has to be declared, right? At the same time, the courts not only examined the gravity of the offense but also the condition and the reformability of the accused. That is there any scope of the reform or reformability of the accused, that also has to be explored. Now students, in Bachan Singh versus State of Punjab 1980, the court although refused to declare death penalty as unconstitutional, right? So although the court has given a humanistic liberalism approach to the death penalty, it has clearly said that only if the case is rarest of rare and no other option is available, only in these circumstances death penalty can be imposed or can be declared. But at the same time, it has refused to declare that death penalty is unconstitutional, correct? We all know that we have Article 21 in our Constitution, which talks about right to life and personal liberty, and it clearly says that no person shall be deprived of his life or liberty except for the procedure established by law, right? That means if the law says to take away the life of the person or liberty of a person, then definitely it can be infringed, right? And definitely in India the death penalty is still not unconstitutional, right? So therefore the article starts with the statement that the top court may have to look, at the core question in Bachan Singh versus State of Punjab, and the question is the constitutional validity of the death penalty, right? So in this way, the mitigating factors has to be explored, and the trial should always be individual centric and not offense centric, right? So this was Bachan Singh judgment, very, very important, a landmark case of the Supreme Court, right? Now, as I said that the approach should be person centric, and there are many other cases like Ravji versus State of Rajasthan in the year 1995. In this, the Supreme Court said that it is the nature of the crime and not the criminal which is germane for deciding the punishment. That means again you are talking about the offense and not the offender. In this sense, the process must be offense centric and not offender centric. It should be person centric, right? It should be individual centric. It should be reformist, right? And it should look into all the mitigating factors to avoid death penalty. So in Irfan versus State of Madhya Pradesh, the recent case, the court has to, the apex court, the higher courts must actually, look into Bachan Singh case, Ravji versus State of Rajasthan case of 1995. At the same time, in Machi Singh versus State of Punjab, again a very important case, Machi Singh versus State of Punjab 1983, the court had indicated that inadequacy of other punishments could justify the death penalty. So in this sense, it has taken a U-turn, right? That means if you don't have any other options left, then only you can justify the declaration of death penalty, right? Now these negated the humanistic liberalism approach in Bachan Singh, right? Because they all were diametrically opposite to the Bachan Singh case, right? There have been many cases, guys. For example, Santosh Kumar, Satish Bhushan Bariyar versus State of Maharashtra in the year 2009. Then Rajesh Kumar versus State of 2011. There was an article in the Frontline magazine which says that out of 13 convicts who were directed to be hanged in different reported cases which were decided by the Supreme Court illegally, right, a case was against the death penalty, right, and it issued and had a list of 13 convicts who were directed to be hanged in different reported cases decided by the Supreme Court itself illegally and erroneously by discarding the Bachchan Singh philosophy. So where Bachchan Singh philosophy talks about humanistic and liberalistic approach, a humane approach, individual-centric approach, the 13 convicts where the court declared them the death penalty is actually the deviation from the Bachchan Singh philosophy, right? So in this way, there is one more important case which has been highlighted, that is Kedarnath Singh versus State of Bihar, 1962. Now in this case, the court endorsed the validity of sedition law, right? Sedition means any act against the government. Sedition law, section 124A of the Indian Penal Code, with the rider that it could be invoked only when there is an incitement to violence, right? That means the court in Kedarnath Singh versus State of Bihar 1962 has clearly said that sedition law can be invoked only and only when there is incitement of violence. If there is no violence through the sedition, because sedition may also be through your speech, right? But if it is not resulting into violence, then the sedition law under Article 124A must not be used, right? So only when there is an incitement to violence, you can use you can use section 124A under sedition law, and this was something said in Kedarnath Singh versus State of Bihar 1962, right? But these days we have seen that people are being charged under the sedition law merely because of the words that they have that they write on the social media, the memes or the tweets or the harmless jokes, right? So for these also, the people are being charged under sedition law. So therefore, it is again a deviation from Kedarnath Singh case of 1962, right? So these gaps within the Bachchan Singh has to be explored, and the question of the constitutional validity of death penalty must be actually looked upon, and this is a time where the country like India should actually look upon this clause from the Bachchan Singh angle, right? Guys, even in United States, in the case of Williams versus Taylor 2000, the American Supreme Court has said that failure of the defense lawyer in highlighting the mitigating factors that could lead to avoidance of capital punishment makes the legal assistance ineffective. That means जो लोग poor हैं, those who cannot afford the very expensive legal services, those who cannot afford the highly, the lawyers who charge high fees, for them it becomes very difficult to defend in the court of law, right? And that is the reason why they are being sent to gallows, correct? So therefore, and this was explored by the American Supreme Court, that because they are not in the position to have strong defense lawyers, and that is the reason why the mitigating factors are not being properly explored, and the death penalties are being given, right? So they have explored way back in the year 2000, right? Now the time has come that we must also look upon these issues, because most of the convicts who are being charged with the death penalty are the one who are uneducated, they are illiterate, they are coming from poor families, right? So they cannot actually hire the expensive lawyers, right? So that is the reason why many death sentences are still there, right? I'm not talking about the rarest of the rare cases, but even for the other cases. So the lack of proper defense lawyer results in the conviction, right? So all the socio-economic and hereditary backgrounds of the accused must be properly assessed, and as I said, that the team of psychologists, psychiatrists, anthropologists must be actually called upon to understand the psyche and the social background of the accused. And there is a possibility for the new juridical device also meeting the unfortunate fate which the Bachchan Singh verdict faced, right? So as I said that many nations have already done away with the death penalty. There have been 144 countries which have been done away, which have given up the death punishment in law and also in practice, as per the report of the Amnesty International. So this is the time has come for the judicial abolition of death penalty, and the omission in Bachchan Singh case should not be done, right? A very important article, guys, important for the UPSC students and also all the law students, right? Moving to the next news article on the screen. Now this article talks about this is taken from Indian Express newspaper, and as we say that we don't limit ourselves to the Hindu, but we also cover the important news articles from Indian Express. So the article talks about the Indonesia's palm oil export ban. Students, Indonesia has actually banned the palm oil, a very important edible oil, right? And Indonesia is the topmost exporter, producer and consumer of palm oil, right? And India on the other hand is the topmost importer of palm oil, right? तो अभी इंडोनेशिया ने जो है इसके ऊपर एक्सपोर्ट के ऊपर बैन लगा दिया है because of the pandemic. There was crunch in the labor, right? So there was labor crunch, right? So labor was not available, right? And that is the reason why the production got adversely affected. The prices shot up, and they themselves have huge domestic requirement of the palm oil. That is the reason why they put the ban on the cooking oil, right? So Indonesia has announced the ban on the palm oil exports to reduce the domestic shortages of the cooking oil, right? So they may ask you that which among the following countries is the topmost producer, exporter and consumer of palm oil? Answer is Indonesia. Which among the following is the topmost importer of palm oil? The answer would be India, right? Now the reason I've already said that because of the pandemic there was labor crunch, the resources were not available, and because of this reason the supply of the palm oil also got affected, right? And therefore there is a crunch and there was a shortage in the domestic industry in Indonesia, and that is the reason why they have put a ban, right? So it has definitely adverse effect on Indian economy. Why? Because the food prices are already skyrocketing post the Russian invasion of Ukraine. The prices have risen by 13% globally as per the report of United Nations, and any further ban on palm oil would have detrimental impact on India, because of the reason that palm oil is definitely used as a cooking oil apart from the soybean oil, the mustard oil, your rapeseed oil, so on and so forth, right? And all the commodities have seen shortfall, possibly because of pandemic or because of poor monsoon in other countries. We'll see. So palm oil is widely used vegetable oil, and it is used as a cooking oil in cosmetics, in food, cakes, chocolates, shampoos, cleaning products, soaps and biofuel, right? So it has immense application, right? At the same time it is inexpensive, right? And Indonesia and Malaysia together account for almost 90% of the global palm oil production. Britishers were also did recognize the potential of these countries, and they started the commercial plantations of palm oil, thereby exploiting the environment, right? So they were not following the environmental friendly practices. Guys, these are the 4 most widely used edible oils in all the countries: palm oil, soybean oil, rapeseed. Rapeseed is something which white sarson, right? So it is white sarson, white mustard. Then you have sunflower oil, right? So these are the 4 edible oils which are being very much used in the households, right? And Indonesia is responsible for 60% of the global supply of palm oil. Now if I talk about the other edible oils, definitely the prices of all the vegetable oils has risen up, right? We cannot blame everything to the government. We must understand that government also imports these commodities from outside, right? For example, soybean. Now there has been a soybean oil mostly is being imported from the country Argentina, right? And there have been poor soybean season in in Argentina, right? Because of the poor monsoon, the soybean crop has been adversely affected, and that's the reason why soybean oil in India has also increased. I mean, the price. As far as the canola is your rapeseed or the white mustard, which I just explained. The production of canola oil comes from, I mean, the supply comes from Canada, and the Canada also, the last year it was a drought season, right? There was no rainfall, and even the supply of the sunflower oil comes from Russia and Ukraine, right? So we all know the situation in Russia and Ukraine, and therefore, and 80% to 90% sunflower oil comes from Russia and Ukraine, right? So, and because of the war in Ukraine, the sunflower oil prices have also risen sharply, right? So all the prices, the soybean oil, sunflower oil, the rapeseed oil, and the palm oil prices have increased, right? And so that is the reason why we are seeing the increase in the prices. And due to in Indonesia, I just have explained that due to the short supply of the alternate vegetable oils, because even Indonesia imports the soybean oil from the other countries, and as I said that their production is also adversely affected, and because of the pandemic they also had to face the labor shortage, and that is the reason why the palm oil was the production was dropped down. So now they have completely banned the export of the palm oil to India, right? And so it would definitely have an adverse impact on Indian economy, and the prices are shooting up, right? Are raising the bar. The formula that the Indonesia government has come up is something called as 2 liter per person rule, right? So they have clearly said that for every person, a person cannot consume more than 2 liter of palm oil, right? So in this way, they are putting restrictions over the consumption, because there are cases of hoarding of the oil, right? And so therefore the government of Indonesia is moving in the direction of actually restricting the use and export of the palm oil, right? So this is all there. India meets half of its annual need for 8.3 million tons of palm oil from Indonesia. As I said, that India is the biggest importer of palm oil, right? And a very important article from Indian Express, right? That's all for today, guys. I hope you liked the session. Press the bell icon for the regular updates. Do like, share, and comment. That's all for today. Wish you all the best. God bless you. Bye.